The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for three separate cases. The first case is Polk County Assessor versus Iowa Public Information Board. The second oral argument is State versus Miranda Rincon. The third case will be submitted without oral argument in the interest of LB, and that case is hereby submitted now without oral argument. We'll start with the Polk County Assessor versus Iowa Public Information Board. Ms. Gavin, you may begin.
May it please the court. Counsel, Chief Justice, I'm Meghan Gavin here on behalf of the Polk County Assessor. This case comes to you on a judicial review petition wherein the Iowa Public Information Board found that the Polk County Assessor violated Iowa's Open Records Act by refusing to provide a list of property owners within the county who had requested to have the name search function for their property disabled on the assessor's website. This case presents the first opportunity for this court since the board was established in 2012 to examine and adjudicate what the board's statutory requirements are under its enabling statute, Iowa Code Chapter 23. Under Iowa Code Chapter 23, the board has the powers and duties to investigate, prosecute, and adjudicate violations of the Open Meetings Act and the Open Records Act. Despite the chapter's repeated use of the word violations, the board has asserted throughout the multi-year course of this case that it only has to prove three things: that a public records request was made, that a responsive record exists, and that the custodian of that record declined to release that record. The assessor obviously disputes that characterization of the board's obligations.
Proof, but since the Chapter 23 is silent on the burden of proof, wouldn't we read it together with Chapter 22, which then would put the burden on the assessor to prove up the confidentiality and exemption?
Justice Waterman, we would disagree that the chapter itself is silent. It does not admittedly say the burden of proof is upon the custodian, or conversely, the burden of proof is on the board. However, it does repeatedly, as I mentioned, use the phrase violations. And I think that is a deliberate distinction from what you're referring to, which is the explicit burden shifting analysis that is in civil enforcement actions in 22.10. So we do think you can read them in conjunction. We don't believe, however, that that helps the board's arguments.
With respect to the specific exemption at issue, how exactly would the board go about proving that the communications, that the government body receiving the communications reasonably believed that that they would discourage people? How would, it seems it would be hard to put that burden on the board.
I don't know how difficult it would be to put that burden on the board. I think you would start in any given case with interviewing the custodian of the record. And then in this case, you can interview his IT personnel to see what the capabilities are of producing the type of record that was requested, which admittedly exists in electronic form. We've never disputed that a record is producible. Whether or not it's responsive is another question. You would interview the staff that takes those requests to have the name search function disabled. You could obtain a list of the property owners. I'm not suggesting that the board need interview the thousands of people on that list, but anyone would be a step in the direction of investigating an interview, of conducting an investigation, I mean.
Related to the burden of proof, but do you agree that under Chapter 23, since the board is vested specifically with interpretive authority, that means that under 17A, deference is owed to the board's interpretations of 22.718?
No, not to the specific phrases that are at issue. I think the specific phrases that are at issue is the word communication and reasonable belief. I think under this court's analysis in Renda and his progeny, we don't look at wholesale as a chapter. You look at specific subsections and words.
In the context where you don't have a specific grant of interpretive authority. Once you have interpretive authority, the legislature has specifically spoken and said, this agency has interpretive authority. Isn't that a situation where it calls for deference?
I would need more, it would have to be a specific question, not on the wholesale, but on the burden of proof issue specifically. Our argument is the burden of proof is an issue of the interpretation of Chapter 23 and not any part of Chapter 22 or specifically the subsections. But I grant you the analysis on the deference issue is different depending on which substantive issue you're looking at in this case.
Have to promulgate a rule regarding its interpretation, and I did not see one interpreting the exemption number 18.
In one, nor is there a corresponding rule regarding the burden of proof. The board has characterized the burden of proof issue as shifting the burden to the custodian anytime one invokes an exception, one of the 70 plus delineated in 22.7. However, there's no burden shifting in 22.7. As this court has noted, that burden comes from a civil enforcement action in 2210. Of course, the custodian would also have the burden in other contexts, such as under 22.8 when it affirmatively goes to court to seek an injunction, or as in the Mitchell decision when the city of Cedar Rapids affirmatively sought a protective order. So we're not denying that, but this situation is substantively different from those three previous situations where this court has acknowledged who has the burden. This is fundamentally different.
What's the public's interest in knowing the names of people who chose to be removed from the name search function?
It's unclear to the county what that public interest is. Mr. Kaufman did testify at hearing as to what his interest was, and he has subsequently published an article, although albeit not the names that are on the list. I would say the public interest would be far greater, Justice Waterman, if it was a question of how the assessor exercised some measure of discretion or judgment in these cases. However, the undisputed record shows that he granted every request by a property owner, regardless of their justification.
I mean, part of the Open Records Act is to sort of shed sunlight on the operations of government, and people might want to be able to say, look up how people who work for Polk County, how they are assessed. Are they assessed fairly as contrasted with people who don't work for Polk County or don't work for the assessor's office? So they might be interested in knowing whether those individuals have chosen to not allow their names to be searched and thus make it more difficult for someone who might be interested in the operations of Polk County and the fair operation of government to track that kind of information. Wouldn't that be a public interest?
I think those are two separate issues, Your Honor. I think there's a separate issue with determining whether or not the public has an interest in whether or not county employees are properly assessed for their taxes. I would agree with you that that is an interest. We have never, the assessor's policy has never even shielded the electronic form of property records. They just simply were not searchable by name. If you searched by address, that name was still linked. At that time, there's been subsequent legislation that has altered this. At that time, it was still linked. And you could also find that information out, Your Honor, by going down to the assessor's office, calling the assessor, emailing.
Difficult, right? I mean, and that argument cuts both ways. If somebody is concerned about their privacy and you say there's a tremendous privacy justification, well, then there's still ways to, skin the cat and get at the property owner's information, right?
There is undoubtedly so. I would liken it, Your Honor, to court records. There is an interest in court records, dissolution of marriage action. One might have an interest in their neighbor's dissolution. You cannot go unless you are an authorized user of EDMS and obtain that information at 2 o'clock in the morning, but you could call the clerk's office and obtain it the next day. I think The evidence in the record, especially from Dr. Warner, goes to this point explicitly on the safety issue component of having such information be readily available to people where there is a safety or anonymity concern.
That you'd to make it harder for people to find where you live, a judge who sentenced somebody, an officer who arrested somebody, a prosecutor who prosecuted somebody. They don't want people with ill intent showing up at their house. But isn't it a separate question of just having your name on a list of people who have been removed from the name search function? What's the harm in disclosing the list of those people?
The distinction that the district court made, that the names, he did not see the security and the safety risk with the names themselves, absent the corresponding addresses. I would point out a couple of things, that addresses can be obtained in different sources other than the assessor's office if you have someone's name that's on the list. I would also point out the bigger issue for the assessor's office is, what legal justification is there in Chapter 23 or even Chapter 22 and your corresponding precedent that would allow the assessor to thread that needle that the names would be permissible but not the names and addresses? I mean, that's a very nuanced argument.
The exemption, it says you're relying on communications not required by law, rule, procedure, or contract that are made, first of all, by identified persons outside of government. First of all, wouldn't that exclude, let's say, someone who works for the county who notifies the county that they want their name removed from the searchable database? That would seem to not include those people right off the bat, wouldn't it?
This context, I think it would certainly disagree information that's provided by county employees when it comes to their official duties. But much like yourselves, county employees are employed both in their official and exist in both their official and personal capacities. I don't think there's a reasonable dispute that they own their homes in their personal capacity, and that is the function of the information that's being provided to the assessor's office has to do with their individual capacities and nothing official related to their employment. And then how do you skin that? Does that apply to federal employees, city employees, state employees? I mean, it's a broad term.
Broad term. Maybe it does apply to everyone in government, because it seems like this is meant to be, when it was written by the legislature, sort of a whistleblowing type thing, that if somebody is complaining about government under circumstances where some adverse repercussions could happen to them if they were identified as a whistleblower, that's what it's meant for, not for somebody who's trying to exercise an option that has been given to them to maintain, keep themselves off a database that most people in the general public have to participate in. So, that just strikes me as very different from what we're talking about here, right?
Disagree that it has that narrow focus, Your Honor. I think the point of that was to increase communications with government and to allow more transparency in government. I think it's also a reflection that the purpose of the entire statutory scheme is to shine sunlight and transparency on government and not upon the information of private citizens. And I think that's what we're getting at here.
I'm a public servant. I think people, I might disagree, but maybe people want to find out. I think people do that. They try and find out aspects of how I've performed my duties. In other words, if I rule on tax cases, maybe they're interested in whether I've paid my taxes or not. That seems to me, there are counterbalancing privacy considerations, but there's also a public interest, isn't there?
Minimal public interest, but I think the assessor's policy is a reflection of that balance. I think that was the point, that the assessor's office became one of the first in the country, if not the first in the state, to put this information, to make it readily available in 1999. But every time you make information more available, there is the balance between privacy and security and anonymity. And I believe what the assessors has done, consistent with the law, is help strike that balance. Again, until the legislature this summer, in Senate File 342, changed the law, the assessor's policy, and no policy in Iowa or permissive in Iowa, redacted information from property records. That is now not the case when it comes to electronic property records for law enforcement, judicial officers, and prosecutors. So I think the public policy that was expressed this summer by the legislature and that balance that does need to take place between individual concerns and the public's need to know has been balanced by the assessor in this case.
That new legislation wasn't in place in 2017. What impact does it have on deciding the issues in this appeal?
I don't think it addresses the exact issue, but it does show, I believe, again, like I mentioned, that the public policy that the assessor was attempting to put forward, the legislature has agreed with him and gone multiple steps further.
In the record supports the reasonable belief that if you disclose the list of names, it would deter communications to request removal from the disabled name list.
The only evidence in the record comes from the assessor's testimony. The sole evidence in the record as to his reasonable belief came from his testimony about his conversations that he had had with people who were on the list, most of which were subsequent to numerous media articles about this case and the potential release of that list. There was no evidence presented by the board to rebut the reasonability of that belief or to demonstrate that any property owners would have made a different calculation. They simply, in the county's opinion, replaced his belief on the reasonableness for their own. If the court has no further questions, I'll save any further argument for rebuttal. Thank you.
Thank you, Chief Justice. May it please the court, counsel. This case, as you know, is not about the release of any addresses. It's simply about the release of a data set that is available in the assessor's database of property owners for whom the name search function has been disabled. I think the board acknowledged in their final decision throughout these proceedings that people who have made this request have legitimate safety concerns. We don't dispute that, but I think the board correctly concluded that, first of all, in this case, there's not a perfect match between the people that made these requests and the final list. And so in the board's view, this data set didn't fall under this 22.718 exception at all because you have a list of approximately 3,400 property owners for whom the name search has been disabled, but there was testimony in the record that of those, maybe approximately 2,100 actually made a request. You have situations where there are spouses, maybe one spouse made the request, both spouses end up having their name search function disabled. Likewise, there was testimony in the record that in some cases, a third party made the request. So, you know, the example of the state court administrator was given who made the request on behalf.
Scramble that omelet. I mean, if it includes some people who are not employed by any government that made a request to have their names removed, if their email in, for example, would fall within the protection of this exemption, wouldn't preparing a list of names of such people also be confidential?
The board concluded the answer was no, and I think in part because based on the substantial evidence in the record, there was really no way to unscramble this list. The board also concluded, and I think the district court judge agreed with this, that you know, even if this list fell under that exemption, because the requests and the names were so intertwined, that the assessor couldn't reasonably believe that most people would choose not to be on the list at all, rather than have their name out there in the public.
It's a combination of names, but isn't there, or first let me ask, is it an objective test to apply this exemption that the records custodian could reasonably believe disclosure would chill the communications?
I think it's a reasonable person test, and in this case, the question is the custodian acting reasonably, or is their belief reasonable?
Just heard about evidence that supports the assessor's conclusion, and from my reading of the record, it seemed like a number of people, upon hearing of this litigation, asked to reverse their decision so they wouldn't be on that list. Doesn't that sort of prove the assessor's point that revealing the list would have a chilling effect on communications?
Maybe as to those people, I do think reading through this entire record and all of the testimony, the concerns that people had seem to be focused on their address being released, including the people that testified at this contested case proceeding. I'll also add there's a number of witnesses here who testified in a public proceeding that their name is on the list.
I agree with you that probably that is the beginning, is that they don't want their address released. But by even having their name as somebody who doesn't want anyone to know, aren't there so many other ways to get around it that you actually have just highlighted your status by having people know this person doesn't want to be found? Isn't it just going to encourage other avenues to quickly find out where are they and maybe defeat the purpose of the request?
Actually get their address, then somebody would still need to go into the assessor's office. I mean, that's my understanding, and they could do that.
I'm talking just all of a sudden you've elevated that person's name. Just the utterance of their name all of a sudden has highlighted them, has put a spotlight on them. This person doesn't want to be found. I just think, doesn't that kind of raise the curiosity? And perhaps that's why, as Justice Waterman referred, why people are saying, take my name off the list. I don't even want it out there, that I don't want people to know where I live.
Possibly with some of the people but that the assessor referred to in his testimony, but I still think that the district court judge was correct in concluding that for most people, they would still prefer to not have their address be searchable from anybody's computer in their living room. I do want to turn to the question about the investigation and the burden of proof. I think that the assessor has conflated the two a little bit in the briefing and the argument, and they are two different things. The board has a duty to investigate complaints if they are unsuccessful in resolving them informally. The purpose of that investigation is twofold. First, the board needs to diligently investigate these complaints to do its job. Second, the purpose of the investigation is to allow the board to make an informed probable cause determination. Here, in this case, the executive director of the board testified about the steps that she took. She interviewed the records requester, who was a reporter. She reviewed the email exchange between the assessor and the reporter. She watched the videotape of the Des Moines Register editorial board meeting where the assessor and the reporter first discussed this topic. She then she talked to the county's attorneys, it sounded like on multiple occasions, and took their position and arguments into account. And then she wrote up a fairly detailed probable cause report for the board. In our view, that was sufficient for the board to find probable cause. It's a different question than what the burden of proof is at the contested case hearing. And the case law is clear that on judicial review, the question is whether the evidence in the record was, whether there was substantial evidence in the record to support the factual findings. In this case, I think there clearly was. I don't think there were really a lot of factual disputes in this case, quite frankly. I think the parties...
Authority point. I think Justice Waterman, may have struck on a fair point, which is if you have interpretive, you have authority to issue rules interpreting, does that also give you authority to interpret the statute outside of the rules? I don't honestly know what we've said in our cases. What have we said on that before?
Is it does, and then you're in that more, I guess, more deferential standard of review. In any event, even if you're just looking at whether there were errors of law, I think under either standard, the board's decision should prevail.
Really focused on whether there was a rule or not. It just said whether it's a general question of whether the legislature vested interpretive authority, and the interpretive rulemaking authority is the best indicator of such interpretive authority, isn't it?
What Brenda said, and Renda goes on to say, even if you don't have an express grant of interpretive authority, which we do here as to Chapter 22, but even if you do not, you need to look at the context. And the context here is you have this board that was created for the purpose of enforcing the open records law and the open meetings law, issuing advisory opinions and binding declaratory orders about those laws. So I think when you look at the context as a whole, it certainly makes sense to conclude that there should be some deference to the way that the board has interpreted.
The board promulgated a rule to interpret the exemption at issue, number 18,
I'm aware of, Your Honor.
the burden of proof.
And I am glad you touched on the burden of proof. I think, I do want to follow up on a question that Justice Oxley asked, which is, I don't know, practically speaking, how the board would go about proving that an exception does not apply. Here I think the county has said, well, we could have called more witnesses to talk about how they didn't mind having their names out there. But taken to its kind of the extreme, their argument seems to be, and there's some of this in the record, that, really they don't have to a respondent doesn't need to put forward an exemption at all. And then, would the board have to go through all 73 exemptions and prove that none of them apply? Also, the weight of this court's precedent for decades now has said that the party seeking to invoke an exception to the open records law has the burden of demonstrating that that exception applies. And I don't know how the board, sitting where it was, could have applied any other standard, given all of the case law that's out there.
The assessors is the one to reasonably conclude if disclosure would have a chilling effect. It's not that the court shouldn't substitute its judgment, nor should the board. Would you agree with that?
Again, going back to your earlier question, I do think it's an objective, reasonable person inquiry. It's the language is, could the custodian reasonably conclude?
Convey it's sort of the hypothetical reasonable person standard. It's an objective standard. It's not really dependent on what the assessor thinks or really what the board thinks or even what a couple of witnesses coming in and giving kind of hearsay testimony would think. It really has to do with what a reasonable, a hypothetical reasonable person would believe, right?
And I think part of the reason for that is you can't possibly predict every scenario that's going to come in front of this board or the courts on this exemption. So it makes sense to have a more objective, reasonable person standard and apply that standard so that people have some certainty about what's expected of them.
What do we do with the fact that the board itself, the assessor's website since perhaps 2002 has promised citizens who make this request that they'll be treated as confidential?
Well, I don't think you can, as a record custodian, create kind of a reasonable expectation of privacy by telling people it's going to be private. And I don't think that's what the assessor was trying to do. I'm not suggesting that he was, sort of trying to set up a defense in a case like this, but I think, generally speaking, the default should be you should notify people this may become public. Ideally, you might have some place for them to give consent at the time that they make the request, although that would be a best practice and not necessarily required. In the Sioux City Press Club case that the county relies on, the government custodian in that case did actually go out to all of the job applicants and ask whether or not they consented to their applications being released. And some of them did, and the custodian went ahead and released those applications, and some of them did not.
Of whether this list itself is a public record or is confidential, in that case, would your position here mean that even if they wanted their application kept confidential, that the city would have to turn over a list of the names of applicants?
I think job applications are distinguishable because they are traditionally private in almost every setting because it could harm your current employment if your employer knew that you were looking for a job. The opposite is true in the context of property records. Property records are public records. That is the default. So to me, the two scenarios are distinguishable. I think also I think your Sioux City Press Club case addresses that question to some extent, so I don't know that you would need to overrule it to decide differently in this case.
Did your appellate brief filed with our court address the who is outside of government? I don't think you did.
I think the board really reached that question either because they decided the case on other grounds. There is some testimony in the record from the board's executive director where she talked about the fact that in another case involving job applications at the University of Iowa, they viewed the University of Iowa as being the government custodian. So they have defined it to be kind of that particular government agency. So that is in the record. But other than that, the board didn't rule on that particular aspect of the county's arguments.
If we view the list as confidential, at least as to private citizens, can we again unscramble the omelet as to requests made by government employees?
And you also, I don't know how easy it would be to unscramble the omelet in terms of commercial property owners. And that was something that the reporter in this case testified about. Part of the reason he was interested in this list and thought that it was newsworthy is because the county hadn't put any sort of parameters around who could make this type of a request. They were allowing everybody to make it, including commercial property owners, and they would just say yes. And he thought that was that was newsworthy in and of itself. And I think it does shed light on the operations of government. I mean, that is the reason for the open records law, as this court has said again and again.
That I think at the beginning that everybody who's on the list has a legitimate safety interest. I think that remains to be shown. There are certainly many people on the list who have a legitimate safety interest. People who have been victims or received threats or have specific jobs, but there may well be people on the list who really shouldn't be trying to take advantage of an exemption that's meant to protect their safety, right?
Right, I think in the commercial property owners would be a good example of somebody who might not have any kind of safety concern at all. I see that my time is up. If you don't have any further questions, we would respectfully request that you affirm. Thank you.
Ms. Willits? Ms. Gavin?
Thank you. I'd like to address a few issues raised by the board. The first is the issue of whether it would be practical for the board to conduct the investigation. Frankly, I don't think that is the question before the court. The question before the court is whether or not the General Assembly put that obligation and duty upon the board. Whether it's practical for their agency isn't the issue. I would also note this idea that it would require the board to prove that all 73 exceptions don't apply is somewhat absurd. They could simply ask, as part of the investigation, what basis the government custodian was relying upon to withhold the record. In fact, in this case, as the record well shows, the assessor volunteered that information in his correspondence with Mr. Kaufman, and despite the 4 years of this litigation, has never wavered on that being the one and only exception that it asserts applies in this case. I think it's also important to note why we do not believe this court should interpret the legislature's use of different words in 23 as intending to adopt the same procedure as in the civil enforcement action. In the civil enforcement action, the reason that the burden is upon the government custodian is because the private citizen bringing the action does not have the record in question. They file that case without that great benefit. They don't have the ability that the board does to subpoena the record at issue, to get the testimony under oath of the record custodian. The two situations are markedly different. And while we certainly would agree that the establishment of the board was to facilitate and make it easier upon private citizens to enforce the open meetings and open records law, That does not mean, conversely, that the legislature intended to make it easier on this new state agency. There's nothing evidence in Chapter 23 that that's the case.
Unscramble the eggs issue. So let's say hypothetically the court were to split the baby and say that people who are private citizens who requested to be removed from the searchable database, that perhaps they are covered by this exemption, but employees of the government or certainly employees of the county are not covered, would not be covered by that exemption. Wouldn't it be up to the county to demonstrate that any record that it's not producing is covered by the exemption? In other words, it would be the county's problem to unscramble the eggs if we reach that result. Am I correct?
Felt that the county had the burden of proof in this case, contrary to what it's argued. Perhaps, I think that argument that the board is bringing cuts both ways, and it cuts to whether or not there is a responsive document to the request at all, because as the board pointed out, the list is over-inclusive to the request that was made. Now, admittedly, the district court and the board said, well, as this case progressed over 4 years, that wasn't how it was litigated. And to some degree, I can agree with that. But the problem is then they want to use that same information as justification for why the list doesn't fit neatly within the confines of the exception. And I don't think that that argument can be had both ways.
Solution be to redact the names or the parts of the document that are confidential? I don't think you can say, well, because this record includes some confidential information, you can't have any of the record. It's more of a redaction issue.
And then it's certainly consistent with your recent decision regarding the Iowa Board of Medicine. And I would, although there's no evidence in the record, I would state that that's probably something the assessor would be capable of doing as it pertained perhaps to county employees. There might be a name matching issue since people could be outside government with the same name as someone in government. It would be impossible, however, if this court took a more expansive view on who was persons outside government, simply because the county assessor does not possess the information regarding the employer of property owners. If there are no further questions from this court, we would respectfully request that the decision of the district court be reversed. Thank you.
Ms. Gavin, the case of Polk County Assessor versus Iowa Public Information Board is hereby submitted. We are going to take about a 5-minute recess before we commence the argument of State versus Rincon. Attorneys for that case may get situated as soon as these attorneys have left the building. Thank you.